Do you think it's more costly to arrest, jail, and take someone all the way to a jury trial to prove up that they're lawfully present here, or for a prosecutor to ferret that out at the front of the prosecution?
Okay, well, we're talking about two different things.
Here.
What I'm talking about is the application of House Bill 4 as far as illegal entry and sending someone, returning them to a port of entry and ordering them to return. The charge is not filed, anything like that. Here, the reality of it is, they would much rather not prosecute this as a Class B misdemeanor and move forward. That's what we do because that's currently under federal law. All these things, as you know, have been federal law. The statutes here are pretty much have been in place for decades. So this is nothing new, but the reality of it is that most people, the counties, nobody really wants to go through the cost and expense to prosecute someone for this unless they can keep from it, because it's an expensive process, it's a lengthy process, and my understanding from dealing with DPS, with Board of Prosecutors, with judges, is that 99% of the time, these people that are actually charged with one of these offenses plead to time served, and they're released. So in the meantime, we're spending money prosecuting them, and in return, it's not a deportable offense under 8 U.S.C. 1227. So what happens is those folks are turned over to ICE, Border Patrol, and then assimilated in the population. So the purpose of House Bill 4 is not to just put more people in jail. The purpose is to return people from which they came if they got here illegally.
Well, hold on. This provision has no application if some law enforcement officer under your bill chooses to, in my opinion, violate someone's due process rights and shoot them back across the border. It doesn't apply because there's no prosecution. What I'm talking about is you've created it, you have at least recognized, isn't this correct, that there are certain circumstances where we shouldn't prosecute or someone shouldn't be convicted of these crimes if certain factors are met. You've laid those out in this affirmative defense section.
Yes.
So those people don't deserve to be convicted of these crimes because why?
Well, I mean, certainly just like when there are different criminal charges under a Texas Penal Code sometimes they have affirmative defenses, and
Sure.
Those apply. The defendant raises those, and then the court will adjudicate those.
No, and I get that. I've been in those courts, not as long as you, but here, the affirmative defense to prosecution is stating that I am lawfully present in the country. I am here lawfully. I have not violated any laws.
Well, that's not the way I read it.
And the position you have put people in,
Yeah.
and correct me if I'm wrong, I mean, I just want to lay out the way I read this. The position that you've put people in is they've got to go prove that up in a jury trial beyond a reasonable doubt because the construct is an affirmative defense, not an exception. Why should this burden not be on the prosecution? Why does this burden lie with someone who's lawfully present in the country?
Well, first of all, I respectfully disagree with your interpretation of that statute, because when you said that they can claim that they're lawfully present in the United States, that's not what the bill reads. The bill says that the federal government has granted the defendant lawful presence in the United States.
Well, does that not mean they're lawfully present?
I'm not sure what that looks like.
Well, if the government says they're lawfully present, are you saying that they're not? I'm confused.
I'm thinking the bill's drafted so that there could be some circumstance, and I'm not really familiar with what that would be, quite honestly, where the federal government has granted someone the lawful presence to be in the United States. It doesn't say asylum. Asylum's separate.
That's a different
deal.
one, yeah.
So, but that could also be if someone's here for a work visa, they have a green card, they have whatever.
Sure,
they have the right
U-visas is another one. So there's other different ways that the federal government can grant someone lawful presence.
I think there are a number of things that fall within that category,
including being a victim of crime. But my point is, if that is a process that my understanding of why this legislation is being proposed is that the federal government isn't doing enough to address these issues at the border, and we have to somehow handle this and create a state level offense to do one of two things: prosecute people here or ship them back across. That's the way the bill is constructed, right?
Well, I don't think that it's that we have to do this. I believe that Texas has the constitutional right and ability to do this and the authority to do this. So it's not, yes, it's precipitated by the fact that the federal government won't do their job. That necessitated the bill. But I don't think it's just because we have to. I think it's because we actually can. And under the Arizona case, we're able to, under the preemption law, the federal immigration laws, we can.
You couldn't possibly disagree with me if someone has gone through a process and the federal government has granted that person lawful presence here, or they've granted them asylum, or they've made a determination that they haven't violated federal law, or that they've been approved for benefits under DACA. And I know that the timing of that maybe doesn't apply to this particular amendment, but in those circumstances, you would agree with me that those people have rights too.
Absolutely.
So why are we putting the burden on them to show that they're lawfully present when they have gone through the process to already get that done? Why would we not say, state of Texas, do your homework and make sure these situations don't apply before you bring a charge?
Yeah, and I understand your concern, and I appreciate your concern, and I think it's a stronger, a higher level than what we typically would require. But I think also that the burden, when you're talking about on the defendant to raise those issues, is not. I don't think you have to get very high to get there. If someone has been granted asylum, that should be pretty simple. I can't imagine if someone's been granted asylum that the prosecutor is going to prosecute anybody.
Exactly. It should be very simple, and the prosecutor is in the best position to know that. And so they should do it at the beginning, because when you make it an exception, the prosecutor in their charging instrument has to negate the existence of that factor. So and I've been through the screening department, you go, okay, I'm checking my boxes. Is this person here lawfully present? I have the ability to figure that out. As a prosecutor, I can interface with the federal government. And by the way, they interface quite frequently. They will tell you whether this person meets any of these check marks. So why wouldn't we just do that at the front end? Because that's the only difference. The only difference. Because in the bill itself right now says, we don't think someone should be convicted of this crime if they meet these factors. And the only difference in the amendment is, let's shift that forward in the process to expedite it. Let's not waste time, energy, and effort, and let's put that burden on the state. Because ultimately, you don't think we should put someone through a jury trial that's here lawfully in the country, do you?
No, I get it. I understand what you're trying to do. I'm just saying that I know a lot of prosecutors.
I'm just trying to protect people's rights. This is a very minute change. This is just shifting the same decision from one point in the trial or one point in the process to an earlier point that creates more efficiency, and that's it. That's it. It doesn't get anybody off the hook.
Gentleman's time has expired.